Well, choking, when you choke somebody, there's only one reason you do that, and that's to seriously injure or kill somebody. I mean, there is no discipline I'm aware of that includes choking.
Welcome back. Monique Gage appeared before Judge John Stevens facing an injury to a child charge, and the case carried serious consequences. At first, the hearing moved through familiar steps. The indictment was read, a document was placed into evidence, but one detail from the allegation made Judge Stevens slow the hearing down. The defense pointed to completed steps after Child Protective Services became involved, and the possibility of moving forward. But the state kept returning to one part of the allegation that was difficult to explain away. Now Judge Stevens had to weigh accountability against rehabilitation and discipline against harm. And before the hearing could close, one question stayed at the center of it all. Was this a case where the court could trust progress, or did the allegation say something more? That answer would shape what happened next.
We call cause number 25CR1459, the state of Texas versus Ranella. Monique Gage, that is you.
Yes, sir.
President. With your attorney, Ms. Minaldi, and the state's attorney, does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about March 20th, 2025, in Jefferson County, Texas, you committed the third-degree felony of injury to a child younger than 15 years of age. It says by striking the child about the head and body with your hands and feet and choking the child. That's what this alleges. Do you understand what you're charged with here?
Yes, sir.
If convicted of this, you face a third-degree felony of a term of not more than 10 years, less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached where you would be pleading guilty and then not found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. And this is a form of probation where there would be terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
I understand.
How do you plead to this, guilty or not guilty?
Guilty.
No, you pleading guilty voluntarily, that is on your own free will, because you are guilty.
Yes, sir.
I'll show you. It's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
No.
without objection. It's admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been good to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided. You're all true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. The pre-sentence report waived here.
Yes, Judge.
Judge, I believe when this first came out, she took some classes with CPS and got those completed. CPS is backed out. The environment she's living in right now, she needs to come back home to mom and the state after discussing and with defense counsel and looking at this, believes it'd be in the best interest for the child that she'd be allowed to go back home to mom. He go back home to mom, sorry. And I know at the time that there was some things going on, we ended up indicting her for it. I'm glad we did because I think it straightened a lot out.
Not unusual for children to need discipline. I mean, that's important.
Yes, sir.
But there is no discipline I'm aware of that includes choking, which is what this says happened, or kicking, punching, or slapping. And apparently the reason all this, he brought toys into the bathroom, into the bathtub. That's what this says. Well, choking, when you choke somebody, there's only one reason you do that, and that's to seriously injure or kill somebody. I mean, that kills people when you shut off their breathing. They have to breathe to live.
Judge, along with the parenting classes, we've also, I think, included the part of the conditions of probation will be that she'll have to attend and complete an anger management program, which I think will further help.
All right, anything else, Dan?
No, Judge.
Where's the child now?
He's living with his maternal grandmother.
What's the,
And there's
the law?
and she's been doing supervised visitations per your order earlier, so they're still having contact.
Has family courts gotten involved in any of this?
CPS has cleared everything and she's done everything that's been required of her, which is all of the circumstances going into the decision for this resolution today.
I guess something like this won't be repeated, huh?
No.
Nothing, you were pleading guilty voluntarily and because you were guilty in this, is that correct?
Yes.
Is that yes? Okay. If nothing further, I'm going to make the following findings: that the defendant is pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation. There are a lot of them. But most of these are terms and conditions of probation that all of us, that are terms of life that we all have to follow, beginning with don't commit an offense, avoid injurious, vicious habits, don't associate with disreputable people. These are all good ideas for everybody, but you're going to be required to follow these. They've also completed anger management program that will be supervised by the probation office. This will be for 10 years. You do well, it can be shortened to 1/3 of this. There is no fine.
There's a $1,000 fine.
It's $500. There it is. Once you slip $500 fine, the probation officer is going to go over these probation terms, make sure you understand them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. So it's serious, and this can be shortened. So, how many children?
We have no child.
Here it is. Please see the probation officer and begin probation. Thank you.
Thank you.
This case is a reminder that accountability does not disappear because a plea is deferred. The law can give someone a chance, but that chance comes with serious conditions and serious consequences. When a child is involved, the courtroom looks closely at safety, proof, and responsibility. Probation is not a reset button. It is a test of whether a person can follow the law and make different choices. The judge made it clear that failure could lead to prison. That lesson does not end when court adjourns. It follows every choice made after. If this made you think, drop a comment below. Subscribe for more real courtroom breakdowns.